Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. First on the docket, the prosecution wants to cut a deal with Ghislaine Maxwell. Wait till you hear what their offer is. Second, the Harmony Montgomery case. Third, an update on that fatal Texas shooting. When you commit crime in Vegas, you stay in Vegas. A little Pokemon Go, and then our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. It is Tuesday, January 11th, 2022. Now, we thank you for joining us. My name is Scott Reich. This is Crime Talk, the most fact-driven, unbiased, true crime channel. Now, if you haven't done so already, please hit that subscribe button. Hit that little bell so you receive notifications when we go live or put up new content. As a reminder, tonight is Tuesday. What does that mean? It means every Tuesday night we go live 6 p.m. Mountain Time. Please join us. Immediately following our Tuesday night show, then we'll do a Patreon show. If you haven't become a Patreon member, you should consider doing so. You can actually call in, and we do a couple of fun things involving, that's right, the Magic 8 Ball. All right, let's get to today's docket. The prosecution wants to cut a deal with Ghislaine Maxwell. All right, so some court filings released today show that the prosecutors are willing to drop the 2 charges of perjury against Ghislaine Maxwell if a conviction for sex trafficking is allowed to stand. 60-year-old Ghislaine Maxwell is due to be sentenced at a later date to be determined, but as of right now, there's an ongoing disagreement over the timeline. Prosecutors want Maxwell sentenced within 3 to 4 months, but her defense team has opposed setting a sentencing date, arguing that there is a compelling basis to overturn the conviction. As you may recall, her lawyers last week demanded a new trial after a juror revealed he had helped convict Maxwell by telling fellow jury members about his own experience as a victim of sexual abuse. That's right, ladies and gentlemen. You can't do that. Wrong. Really, really wrong. Well, the U.S. government has now offered to drop the 2 perjury charges linked to claims that Maxwell made in a 2016 deposition in a separate civil lawsuit should the sex crime conviction stand. Now, each perjury charge carries a maximum of 5 years in prison, and the charges allege the convicted sex trafficker lied under oath by hiding her participation in that guy named Jeff's offenses during a separate civil case brought against her by Prince Andrew's accuser, Virginia Jeffrey. Now, confirming their position in the letter to the judge, the United States attorney said, quote, "In the event that the defendant's post-trial motions are denied, the government is prepared to dismiss the severed perjury counts at the time of sentencing in light of the victim's significant interest in bringing closure to this matter and avoiding trauma of testifying yet again." Oh, I'm sure that's the case. Now, if any of the defendant's post-trial motions are granted, the government proposes that the parties be directed to promptly confer and propose schedules for the further proceedings. That schedule may depend on the manner in which the court resolves the motions for the new trial. Prosecutors are also requesting the preparation of a pre-sentence investigation report, but the defense is arguing that Maxwell shouldn't have to do that until and if there is a retrial and if she is convicted. So let's talk about this, ladies and gentlemen. First, if I was the defense, I would tell the government to go politely pound sand. Ooh, you're going to dismiss a couple of perjury charges, a charge that rarely, if ever, gets prosecuted in court, let alone federal court. That was a tag along and really has no relevance whatsoever as it relates to the case of Ghislaine Maxwell. Sure, they're charges, but whatever, okay? Those charges are certainly not Ghislaine Maxwell's biggest concern. I assure you not. Now, the court, and I hate to say this, the court should grant Ghislaine Maxwell a new trial. The juror that came forward and actually told the press that he explained how he remembers things and talks about his experience as a sex crime victim, guess what? That's wrong. That means he didn't go into the trial as a fair and impartial juror willing to reserve judgment after listening to all the evidence and then follow the court's instructions. It is becoming rather clear that not one, not two, but now up to 3 jurors may have lied on their juror questionnaires by not revealing information that was plainly and straightforwardly asked of each and every individual that was going to be on that jury. And when jurors don't answer truthfully, guess what? They are no better than the individuals sitting over there at the table with the nameplate that says defendant in front of them. So the bottom line is the defense needs to tell the government to go pound sand. The judge needs to grant Ghislaine Maxwell a new trial. The juror needs to be held in contempt, possibly thrown in jail, and should, as a sanction, have to pay for the attorney's fees and costs associated with the defense and the prosecution having to come back and do that trial over again. The question now becomes, will the court have the guts to do the right thing? This is simple litigation 101. When you find out jurors have lied, or they bring in extrinsic material to a courtroom in their deliberations other than what was legal and competently presented evidence that was admitted into evidence, it's a do-over. It is a do-over, and the government needs to confess the motion for a new trial. The judge needs to grant it. Whether you are a fan of Ghislaine Maxwell, and I doubt there are very few fans of Ghislaine Maxwell, or you think that she is the biggest scum of the earth, the bottom line is she deserved a fair trial. And imagine, ladies and gentlemen, if you or a family member was sitting in that courtroom at a table with a little name placard said defendant, that's right. You would want to make sure that those jurors were fair and impartial and didn't lie to get on that jury. And so therefore, new trial. All right, next on the docket, let's talk about the case of Harmony Montgomery. So the police have continued to keep the investigation into 7-year-old Harmony Montgomery's disappearance pretty tight-lipped. Over the past several days, search teams have taken special equipment and tools to the Manchester, New Hampshire residence where Harmony lived with her father in November of 2019. Now, police sealed off the crime scene and began digging in the backyard with the help of a ground heater, which is used to thaw the soil. Harmony's mother, Crystal Sorey, S-O-R-E-Y, you guys let me know if I'm mispronouncing that, reported Harmony missing on November 18th of 2021. Now, Sorey and other family members haven't seen Harmony since 2019 because Harmony's father, Adam Montgomery, had physical custody of the child. Now, Sorey had lost custody of the child in 2018 due to drug issues. At the time, both Adam Montgomery and his estranged wife, Kayla Montgomery, have been arrested in connection to the disappearance of Harmony. Adam claims he dropped Harmony off with her mother in 2019 and never saw her again. Adam is also facing assault charges after he allegedly struck Harmony in the front of others, family members, back in 2019. Now, as Kayla Montgomery has been charged with welfare fraud after she allegedly obtained $1,500 in food stamps for Harmony, even though the girl was not living with them at the time. Now, in an interview with the police on New Year's Eve, Kayla Montgomery, who shares 3 children with her husband, ages 4, 2, and 1, said she last saw Harmony back in December of 2019. She said her husband was driving Harmony to the child's mother in Massachusetts. She said she believed Harmony had been returned to the mother and never saw or heard about Harmony after that day. That's all according to the police statements. Now, Kayla Montgomery also told police she hadn't seen Adam since October and had not spoken to him since November. Adam Montgomery, 31, was charged last week with several counts, including failing to have Harmony in custody. He pled not guilty and has been jailed without bond. Kayla Montgomery's attorney filed a motion asking for a bail reconsideration, and prosecutors responded saying they anticipate filing theft charges and 8 misdemeanor charges, which have somewhat been unspecified. The welfare charge would be dropped, but the bail will remain at $5,000. Now, the uncle of Adam Montgomery has said he tried to report the incidents of child abuse to authorities for years, but no one ever acted upon those reports. This is not Adam Montgomery's first run-in with the law. In 2014, he was accused of shooting a man in the face while trying to rob him of 3 grams of heroin. Montgomery pled guilty and received an 18-month sentence. At the time, Harmony was just 4 months old. Harmony has been missing for 2 years now, and police spent the last 2 weeks searching Adam Montgomery's property, but they packed up Monday afternoon without announcing any information. Police records show that they have responded to more than 24 phone calls at the residence, ranging from animal and nuisance complaints to domestic disputes and child welfare. And Harmony is about 4 feet tall and 50 pounds. She has blonde hair and blue eyes and should be wearing glasses. She's also blind in her right eye. If you have any information about Harmony's disappearance, you can call the tip line set up by the Manchester Police Department at 603-203-6060. Now, unfortunately, this sounds like a case where a lot of times it doesn't turn out very well. The mere fact that nobody noticed a child has been missing for 2 years and nobody said a single word, unbelievable, ladies and gentlemen. It just shows you got to get a license to do just about anything in the world, but anybody that can reproduce can be a parent. Unbelievable. Next on the docket, let's talk about that fatal Texas shooting and give you an update. Remember the video we brought you of the fatal shooting on the Texas porch during an argument over a custody swap of some children? Well, the divorce case that launched the fatal fight has been dismissed. On November 5th, Chad and Jennifer Reed had gone to Kyle Carruth's home to pick up Chad and Christina's son. Chad and Christina started to argue over the time Chad was supposed to pick up the child. Jennifer started recording the fight on her cell phone, and during the argument, Kyle is seen going into the home and emerging with a shotgun. Then Kyle shoots into the porch near Chad's feet. Chad then used the gun as leverage to push Kyle away from him, at which point Kyle fires 2 shots at Chad. Jennifer Reed, the widow of Chad Reed, had sought to intervene in the ongoing divorce and custody matter between Chad and his ex-wife, Christina Reed, after Jennifer recorded cell phone video of Christina's boyfriend, Kyle Carruth, appearing to shoot and kill Chad during the fight. Now, at the time, Jennifer said in an affidavit that Chad's oldest child told Jennifer that he blames his mother for the shooting and that he will run away from home if he sees Kyle there again. Now, Jennifer also said in the affidavit that one of Chad's children will tell the family court judge that he wants to live with Jennifer. Now, however, according to Jennifer's attorney, Matthew Harris, the family law case has been dismissed. Jennifer Reed and Chad's mother, Jinx Red, have each filed wrongful death lawsuits against Kyle, who has requested that the case be transferred to a different county. It's always about the money, ladies and gentlemen. And can we just say, let's face it, I know when you get married, you think it's going to last forever. Sometimes things don't work out. You hope it's when you marry somebody that they are the one, right? But if things don't work out and you still got kids, you got to try to get along, right? You're stuck with these people for the rest of your life because you've had children together. At least get along. And you're fighting over, well, you were supposed to have the kid here 10 minutes ago and the kid's not here, and now somebody's dead over arguing about the timing of a custody exchange. Give me a break, ladies and gentlemen. Now, to date, no charges have been filed, but maybe a jury one day will have to decide whether it was self-defense or it was murder, not justified. The bottom line is, really? We've said this before. Let it go. Let it go. Let it go. That's all I can say, ladies and gentlemen. Next on the docket, when you commit crime in Vegas, well, sometimes you stay in Vegas, kind of like with all your secrets. So 2 California men have been charged with 13 felonies in connection to their time allegedly committing armed robberies leading up to New Year's Eve in Las Vegas. Authorities allege that 2 men committed several armed robberies in and around the Las Vegas parking garages December 30th and 31st, 2 of which ended in shootings that killed 66-year-old Clarice Yamaguchi and 60-year-old Hoi Sup Richard easy for you to say. The alleged shooters, Jessani Carter, 20, and Jordan Ruby, 18, were denied a chance to be released from jail until charges were already in progress. The judge, Harmony Letisa, refused to release the men, saying they were clearly a danger to the community and called them criminal predators. Good for you, Judge. The charges were expanded Monday from an initial 3 counts to 13 felony counts that included attempted murder, robbery with a weapon, and conspiracy to commit robbery. Now, prosecutor Mark DiGiacomo has said that the case may be considered for the death penalty. Listen, these two yahoos, they've got to be some of the dumbest people in America. And if it wasn't so damn serious, they would be a dumb criminal contestant for sure. Okay, let me tell you this, ladies and gentlemen. Just about every inch of property in Las Vegas is covered by video cameras. Nothing takes place without somebody watching it on video or being recorded. So these two knuckleheads, first of all, they come into Las Vegas from California to commit crime. They rob people and actually kill people. Yeah, that's getting up there with like death penalty stuff, don't you think? Come on. Unbelievable, ladies and gentlemen. Those two young lads should have just gone to Vegas and done what everybody else does. Engage in sin, maybe shoot some automatic weapons, but not harm anybody. Come on, you know better. Pokemon Go. Okay, my kids used to have Pokemon cards. Now there's adults doing the game Pokemon Go. Can you believe it? So a California appellate court has upheld the firing of 2 Los Angeles Police Department officers who ignored a robbery call to play Pokemon Go. On a Saturday, April 5th, 2017, Luis Lozano and Eric Mitchell were working together as partners for the Los Angeles Police Department Southwest Division when a call came in on a 211, a robbery in progress involving multiple suspects at a Macy in the Crenshaw Mall. Many attempts were made to contact the 2 officers. Mitchell claims he did not hear the call, and Lozano claimed he had heard someone else respond to the call. Both claimed they had trouble hearing the radio because it was very loud in the park that day. The next day, Sergeant Jose Gomez checked their digital in-car video system when he discovered something troubling. The duo could be heard mocking Captain Davenport, who called in for help. The partners then misrepresented their location by claiming to be responding to a different call somewhere else. Lying. Further investigation was that the duo had been doing that day. The detective assigned to the investigation found a recording that showed Officer Lozano saying, "Screw it," regarding the call about the robbery, and Officer Mitchell saying, "Snorlax just popped up at 46 and Lemert." For the next 20 minutes, the officers were caught on video discussing Pokemon while driving to different locations trying to catch the Snorlax and other Pokemon. For those not familiar with Pokemon Go, it was a popular cell phone game where players could find and capture various Pokemon characters within the game's digital world by traveling around in the real world. The users would aim their phones at the digital creature and capture the Pokemon. The more rare the Pokemon, the better the capture. Hence the excitement caught on video of the officers when they caught the rare Snorlax. The officers tried denying playing the game and said they were just talking about the game. The board found that ignoring a real-world robbery, not to mention the request for help from their fellow LAPD officers to chase down a Pokemon character, instead would certainly be classified as egregious. The board unanimously, but not unexpectedly, recommended that both Lozano and Mitchell should be fired, and the chief of the LAPD followed that recommendation, as well they should have. Yes, that case goes back several years, but listen, if those officers joined the police department for any other reason than to serve and protect the community, guess what? They shouldn't be there. If you don't like your job, go find a new one. It's that simple. All right, next on the docket, Andrew Lloyd, 51, from Oregon, stole $3.5 million in pandemic relief funds and invested half into Tesla stock. Now, Lloyd took advantage of the PPP and small business loans available during the pandemic and submitted phony payroll information to secure the $3.5 million. The stock has since skyrocketed in value from $200 a share to $1,100 a share and was now worth more than $16 million, all of which was seized by the United States government. Now, Lloyd, who owned 15,000 shares at the time of his arrest, was sentenced to 4 years in prison after pleading guilty to federal bank fraud, money laundering, and aggravated identity theft charges. And guess what, ladies and gentlemen? He doesn't get the benefit of the gain at all because it was all purchased with illegal gotten gains. Simple rule there, ladies and gentlemen. Kind of the theme of the day. don't lie. All right, that's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk. Please join us tonight, 6 p.m. Mountain Time, for our live show.